Hello, everyone, and thank you for staying on a beautiful day at 4 o'clock at the beach and listening to a speech on compliance. So I promise to try and make it interesting as well as informative. So who am I? That's your first question. My name's Soffer. I am an attorney, but unlike all of the other wonderful attorneys that have spoken before me, I do not do any litigation or first-party property damage claims. I represent public adjusters and contractors. I help public adjusters and contractors with compliance documents, and also I represent 2 public adjuster associations. One is, sorry, the lights are really blinding, so I'm going to have to look on either side and not in the middle. I represent APIA, which is the American Association of Public Insurance Adjusters. Thank you for dimming them. And MAPIA, which is the Mid-Atlantic Association of Public Insurance Adjusters. They all rhyme. In fact, there's one of our board members walking in right now, Brenda Hefner. She's on the board of MAPIA, and Matt Mulholland is the vice president of APIA. He's sitting in the back with the hat. Everyone knows Matt. So through representing the associations, I, on a daily basis, track any new laws and regulations that affect the public adjusting industry. Not so much contractors, I have to research that, and also we track laws on unfair trade practices and appraisal. There's an appraisal bill in Louisiana that I've been talking to Bob Norton about all morning, and pretty much, maybe a few other issues that come along. So what I'm going to talk about today, and we'll see if I can work the clicker, there we go, is multi-state adjusting. How many people here are licensed in more than one state? Oh, good, so almost everybody. And how many are from Texas? Okay, a handful. If you're from Texas, I always say if you're from Texas or Florida, you know about regulation, because those are very heavily regulated states, especially Florida. If you're from Florida and you want to practice in another state, you're aware that there are lots of rules and regulations that govern public adjusting, and you're aware that they're different in every state. So this is just a little outline of some of the issues we'll be talking about. I'll try at the end, if we have time, although I don't think we will, to get into, how many people here are contractors only? Okay, a few. So I'll try and get into some of those, but it's really going to be geared mostly for the public adjusters. Contractors, do you do residential or commercial? If you're doing all commercial work for your contracts, you can pretty much put whatever you want in them. Most of the contractor rules just govern homeowner claims, so I won't get too much into that. Oops, let's see. Okay. So with regard to licensing, as you probably know, 46 of the 50 states, plus the District of Columbia, plus Puerto Rico, plus the Virgin Islands, license public adjusters. And I actually had a client call me this morning and say, I want to do public adjusting in Germany. What are the licensing requirements? That I have no idea. I'll have to warn you. I'm going to have to write back to him saying, I think you're going to need a lawyer in Germany. So with regard to licensing, there are different, if you're starting in one state, you need a license, obviously, in every other state. Some states have emergency licensing after a storm, where just like insurance company adjusters, you can come in and either get a fast-track license, which usually only lasts for 3 to 6 months, or get a full license on a quicker basis. With regard to reciprocity, I don't know if most public adjusters are aware, but not every state is reciprocal with every other state. Some states, you have to take the exam no matter where you're from, but other states will say, for instance, if you're from Florida, and I know a number of people here are from Florida, there are about 6 states that are not reciprocal with you. So you have to go in and take that exam, although if you're from Pennsylvania, you can work there. If you're from Florida, you can't. So just be aware of that. And then entity licensing and bonding. So if you have an individual public adjuster license, the majority of states require you to license your company or entity as well. Not all. There are a handful that don't, but most do. So that's an easy way that most public adjusters get fined because they go operate in another state and they don't have a license. And some states like New Jersey will try and revoke your license for that. They'll say you're acting as a public adjuster without a license, even though a licensed person is working on the claim, they will say you don't, and not every state requires bonding. Some states will say for the company, some do, some don't. Florida has a crazy law now that says you have to maintain your bond for a year after your license expires, except in Florida, your license never expires. So that's an odd one, except if Florida has a weird self-appointing system. If you're not appointed for 4 years, then your license expires, and then you have to maintain your bond for a year after that. So if you have an individual public adjuster license, say in 5 states, and you haven't had a chance to register your company, and you call me and you say, Holly, I got this $20 million claim and I want to take it right away, some states are 2 months behind for entity licensing. So don't wait until you have the $20 million claim. If you want to work in certain states, get it done now. Otherwise, you can work there as an individual, but then you can't put anything out on company letterhead, you can't receive any money into the company, and you can't communicate with the carrier on behalf of the company. And you won't be covered by your company E&O policy because you're acting outside the company. And your accountant will be very mad at you because you're going to be receiving money in your own name, not depositing it in the company. Actually, to keep everyone laughing, I will tell you my one accountant joke. So my accountant happens to be a good friend of mine who I've known for many years. And as some of you may or may not know, I had a serious foot injury last year. The last time I saw some of you, I was on crutches, hence the sneakers with the dress. I can't wear heels anymore. But anyway, so I was talking to my accountant, and I said, Carl, this year I may want to do a 401k. And he said, I don't know, Holly, with your foot injury, I don't think you should run that far anymore. So anyway, that's actually somewhat of a true story. But anyway, so if you're doing licensing, NIPR is a way there. You can outsource licensing. There are companies, there's SIS. If you're a public adjuster who has 20 employees and you're licensed in 15 states, you either have to hire a full-time person to do it or you can outsource it to a company, Supportive Insurance Services. My office does help with that, but if you have that many people, 50 people in 35 states, we're not going to take that on for you. We'll help you in 5 or 6 states at a time. But SIS is expensive, but it may be cheaper than hiring a full-time person to do it. And sometimes you have to answer questions on the application, not just upload it onto NIPR. If the license application says, have you had any actions in the various states within the last 2 years, and you say no, but you uploaded all the information on NIPR, you're still going to get investigated. I have a situation like that right now in California. Reporting. Speaking of California, you have to report within 30 days if you have a violation in another state, any administrative action against you. I have a client now who had a change of address violation in Nebraska. You have to report your change of address within 30 days. They did not. They got fined. They failed to report that to California, and now it's snowballed into a major thing in California where they don't want to renew their license because they didn't pay the fine in Nebraska because they said they didn't get the email. So it went from a $250 fine to a $1,000 fine to a $3,000 fine. Then they failed to report it in California, and now California said, we don't want to renew your license, and we're negotiating back and forth. I'm going to get it renewed for them, but they're probably going to have to pay California $5,000 as a fine. So pay attention to stuff like that. Let's see, I'm pushing the next one, and it's not working. There we go. So this is going to be the most important thing. If you take nothing else out of this presentation, know that you cannot use the same contract in every state. You can't do things the same way. You can't use the same forms, and you especially can't use the same contract in every state. Some states make it easy. Pennsylvania has a form contract. You have to use it. You can't even change the fonts without their permission. They'll allow you to make changes if you ask, but if you say, well, it's 3 pages and I want to condense it down to 2, or put something on the reverse instead of on a separate page, no, they'll come after you for that. So if a state has a form, I always say if you're just starting out as a public adjuster, just use the form. Make it easy, keep it simple. If you develop a specialized practice and you know you need certain things in your contract, then you can change it over time. But if you're just starting out, use the form. When I have with insured there because you can't sign a contract with a contractor. That's why it says with insured. There are some people who get paid by contractors as public adjusters, and that's fine, but you still have to go, in some states, that's fine, you still have to go and get your contract signed with the homeowner, even if the contractor has an AOB. In some states, they still require you to go sign the contract with the homeowner. They don't care about the AOB. So make sure your contract is signed by the insured. In a lot of states now, this is a growing trend, you need state approval of the contract. Georgia required state approval since 2021, just FYI. They just changed their contract rules just within the past few months. It's a simple language change, but you're going to need to resubmit your contract to Georgia with the new language change. Kentucky will now require contract approval. They just passed a new law this legislative session. Kentucky, though, has not set up a system to do that. So technically, by July 1st, if your contract's not approved, you're violating the law. But they have no one that they've appointed to review the contracts yet, as of before I came. Florida did that for about 9 months after they changed their law on something, and Georgia did the same. So I'm trying to keep an eye on what Kentucky's doing because they'll just pick someone and then they won't announce it, so we'll never know when they set it up. But APPIA has a lobbyist there, so hopefully we'll find out. Some states now require that you submit your contract to the carrier. Florida, I see people nodding, Florida has always done that. Indiana just changed their law and they require that. So there are a number of states that are doing that now where you have to give your contract to the carrier. And that's, see, in Florida, some people use their contract as what they call a letter of representation. So they're saying to the homeowner, you know, you're hiring me as your public adjuster, blah, blah, blah. And it's also a letter to the carrier. I don't like that. As a lawyer, I hate that. A contract is an agreement between two parties, not also a letter to a third party. So if you have to give your contract to the carrier, fine, but also do another notice letter. And notice I call it a notice letter and not a letter of representation, because there are a lot of states where you can't use the term represent. So you want to try and make your documents work for you in more than one state. So certainly not Louisiana, because you can't do a lot of things there, and we won't even get into that. But in a lot of states, you can't say you represent. And one thing that I'm kind of doing it out of order, but one thing that's going to come up is I know that a lot of people are taught to, you know, maybe make your notice letter the same as your proof of loss. You can't always do that. That may work very well in one state and may be the best thing to do, but that's not going to work for you in other states. And here's why. Because some states have notice letter requirements where you have to send them out within sometimes 2 days. Pennsylvania is 2 days. Other states are 3 days. And you're not going to be able to complete the whole proof of loss in 2 days. And if you don't send the notice letter, you're going to be violating the law. Your client's going to be harmed, and you're going to be fined by the state. So your notice letter should just be, you can send it with your proof of loss as like a cover letter, but your notice letter should be a separate document, and you have to pay attention to those deadlines. Not only that, in some states, the notice letter triggers the rescissionary period. So it doesn't start until after you send the notice letter. So if you're sending it 3 weeks later, even if there's no requirement, you can do all the work, do your whole proof, do the whole estimate, do tons of work on the file, and then your client can still have 5 or 10 days to rescind your contract after that if they don't want to pay you. So make the notice letter separate from your contract, separate from your proof of loss. Again, if you want to send them at the same time, great, but just make sure that you meet those requirements. So what should be in your contract? You know, a lot of states have different disclosures. The worst thing is when I see a public adjuster working in Kansas and it'll say on there, disclosure under California law, blah, 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 blah. Someone's going to notice that. So make sure it's usually just, boilerplate stuff. Conflict of interest, we'll talk about that later, but, it's usually disclosures like that. I've put things on here, like it's better to have almost like a double negative. I don't have any interest in blah, 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 except for the following, and then if it's none, you put none. That's the language that changed in Georgia. Before that was okay. You had to disclose any financial interest, and now you have to say you have no financial interest. So even if you had, I have no financial interest except the following, and you put none, no other interest, now that's not good enough. They want affirmative language that they've put in the statute saying that you have no financial interest, but nothing else substantively changed. Expense outlines, if you're doing a normal residential claim, you can just put a line in there that says, you're charging for your expenses that are approved by the insured. If you're doing a complex commercial claim, sometimes that doesn't really cover everything. So you may want to put in that you'll be paid right away. As soon as you incur the expense, within 30 days, you'll just bill separately. Or maybe you want to put in saying, these expenses are included, these are ones I will advance, these are ones I will not advance, because maybe you don't want to spend $300,000 advancing expenses on a really large claim. So you can attach an addendum to your contract that goes into all those details. Again, not really necessary on most run-of-the-mill residential claims, but definitely on commercial claims, and we'll come back to some of the other things, but I'll skip down to that. Other things are more appropriate in your commercial contract and not necessarily your residential one, and some public adjusters have two separate agreements, especially in Florida. I see people here from Florida. Florida has totally different rules that govern residential versus commercial claims. Different fee caps, there's no fee cap on commercial claims, different rescissionary rights, different notices that you have to put in your contract on residential versus commercial. So why limit yourself to all of that on a commercial claim if you don't have to? Why give somebody a 10-day right of rescission and make your contract full of all kinds of consumer notices if you're not required to do that? And you can put more teeth in the commercial contract. In terms of a lot of legal mumbo jumbo, that if you go to a business lawyer, which I used to be for 20 years before I started doing this about 13 years ago, my background is in corporate law. Your lawyer will tell you to put all kinds of stuff in your contract that's really not necessary and won't be enforced anyway. You're trying to keep it as simple as possible, even on a commercial claim. So you don't need to put stuff in there and I fought with clients over this, that says, this is governed by Maryland law. Well, it has to be anyway because it's governed by the American Public Adjuster law. You don't need to put stuff like that in your public adjuster agreement because it's already true and you're just putting all kinds of legal mumbo jumbo in there that's going to discourage your client from signing the contract and make it harder to understand. And it's not necessary. So I try and keep it as simple as possible, yet at the same time, making sure that if you're doing commercial work, that it covers everything that you may uncover. Things like you're the exclusive public adjuster on the claim. I had a client in Florida that had a $20 million claim, and they found out later that there were two public adjusters. The person hired two adjusters. They found out from the carrier. So then they had to fight it out with the other public adjuster on who got paid what. So now I've started putting that on commercial agreements. I'm the exclusive public adjuster on the claim, just because, you learn over time, really unusual things happen, and then you put it in your next agreement. So back to the earlier things that we skipped, new money versus prior offers. Some states, you can only earn your fee on money earned after date of contract. Other states, you can say, I take my fee from $1, or you can say, give the homeowner a choice. I'll take X% from $1 or a higher percentage on new money. Just so you know, Maryland recently didn't pass a law or a regulation, but reinterpreted, so if you work in Maryland, their laws to say that you can only take your fee on new money, and they're prosecuting public adjusters who say something else in their contracts and are taking a fee on going back to $1. Our local group, which Maryland is a part of, we're about to put out an announcement They just started doing that within the past few months. I've been talking to them about getting the commissioner to put out a bulletin, and I don't know if she's going to do it, but it's hard to know things like that when they're not in the law or in the regs, and they just kind of change their mind. So be careful about that and check that out. California, that was Maryland. California also requires, California technically doesn't require that, but they're really picky about what you put in the contract. Usually I say use the form contract. California is one state where you shouldn't use the form, because what happened is when the law changed, the insurance commissioner made up his own contract, and it went much further than what the law required. So you can submit your own contract, which is approved by one woman named Risa, who's kind of like the law unto herself, but she's usually pretty fair. I actually like her a lot. But you can get away with putting less in than what the state contract, the form contract has. Collection language, other protections, some states allow you to put in collection language that says, you know, if you don't pay me my fee, I'm going to charge you interest, or I'm going to charge you costs. Not every state does that. In fact, states that follow the Model Act, the Public Adjuster Model Act, don't allow that because that's in the Model Act. Cancellation termination, every state is different. And just know that suppose your state, like Arizona, is anyone here from Arizona? They have no rules there, so you came from a good state. There are no compliance rules for public adjusters. You can put whatever you want in your contract. However, there's a federal 3-day right of rescission law for in-home sales. So if you are soliciting someone in their home as a public adjuster, even though Arizona public adjuster law has no law with regard to that, you still have to comply with the federal 3-day rule. And they still have 3 business days to rescind the contract, only if you solicit in their home. So there are a few other states that don't have specific rescission periods in their public adjuster law. I know that that 3-day rule's out there. Again, only for in-home solicitation. But now we live in a sort of electronic virtual world. What does in-home solicitation mean? Does it mean you called them? Does it mean you Zoomed them? Does it mean you contacted them on social media and then send it out via DocuSign? Nobody really knows, but just be careful about that. The other thing is there are some states like New Jersey that are reinterpreting and have been their cancellation termination rules. So if you're working in New Jersey, you have to go over your contract with a fine-tooth comb, and Appia has filed suit against the Department of Banking Insurance in New Jersey as a declaratory judgment action to ask the court to say that certain language is okay with regard to cancellation, because New Jersey reinterprets it every year and then prosecutes public adjusters. They fined somebody last summer for not bolding a sentence that the law did not say had to be bolded. They just decided it should be. And they fined them $7,000. So our local association is trying to introduce legislation, but so just be careful about that. The main thing is you're going to another state, don't use your contract from the other state. Consider all of these issues. Sometimes it's helpful. If you're coming from Florida, you may be able to put a lot more in your contract in a different state than you weren't allowed to do in Florida, and it will actually be helpful. But also know that just because it's in your contract doesn't mean it's enforceable. Just because you put in, well, you know, I'm going to collect interest and fines. Judges don't often award attorney's fees or interest on debts owed like that, especially on consumer debt. And people always ask me about letters of protection. We should have had one of the other litigators up here talking about that. Your client can't force an attorney to give you a letter of protection. So, and I certainly can't force them to when they come to me and ask me to do it with a different attorney. That doesn't always work. And if the client at the last minute tells that attorney not to pay you, you're not going to get paid. You're going to have to find another way to get paid. So it doesn't always work. That's something to ask a question one of the litigators. So we talked a lot about notice letters. One thing that I've changed in my notice letters, aside from saying you represent, is not to ask for a certified copy of the policy anymore, because I found from public adjusters that when they do that, it takes 3 or 4 weeks to get a policy because carriers have to send it through various departments to get them certified. You can still do it, but if you ask for a full copy of the policy instead, you'll get it a lot faster. And somebody told me that the best way to get a copy of the policy is to go to the person's house, if it's a residential claim, and sit with them and open an online portal to their company. And then usually you can get the policy that way instantly because it's online on their website on that person's account. So I don't know if that works, but you can try it. SAF is a form that I've kind of made up that's now codified in Georgia because I got to help write that part of the law. That's a signature authorization form. Does not work in every state, is illegal in Texas. So if you're from Texas, can't do it. Utah, there are about a handful of states where you cannot use them, but you can in most. And these really started during COVID when everyone was in their house and didn't want to see another person live. And also, I don't know if you remember, but the mail, at least in my area, used to take about 10 days to get anywhere. So public adjusters would get checks and couldn't really process them because sometimes they would take them to them in person or mail them. Mail was taking forever. Inc. hadn't started yet. You've probably heard of that group, Inc. Pay. They now call themselves Inc. That was long before them. So I started these forms where the homeowners give you permission in writing to endorse their name to the back of the check for deposit only into your escrow account. And I put in there that it's revocable at any time, and that's probably the most important line. It's revocable at any time. It's not like they have to send you a notice letter. If you get a text that says, I don't want you signing the check, if they call you and say, I don't want you signing the check, you can't do it. Otherwise, it's forgery. But if you have written permission, you can endorse the check, deposit it into your escrow account, and then distribute it. You have to have the signature of every single person whose name you're going to endorse, which is harder on commercial claims because sometimes you're dealing with the property manager and the check comes to XYZ LLC, and you don't even know who those people are, and you have to get their names and the people who are authorized to sign on behalf of them. Works better with homeowners claims because usually in commercial claims you can just bill them, you're not worried about it. Also make sure you get paid that way. Now if there's a mortgage company, it actually helps a lot because you don't have to send it to the homeowner for signature, wait for it to come back, or have them send it to the carrier. You can just sign your name, their name, send it to the carrier. So it does speed things up a little bit. And Georgia, as Matt will tell you, Georgia wanted to say that checks could only be in the name of public adjusters. And they wanted to outlaw these types of signature authorizations. But we convinced them that they put in certain safeguards saying, again, it can only be deposited into a trust account, can be revocable at any time, and if you do that, that you have to send immediate notice that's accompanied by sort of like a breakdown of where the money went. I got in $10, I took 1 or 2, here's the check for 8. And then you can take it even farther in some states. If they give you permission, you can say, and I've paid, and you give me permission to disperse money to certain contractors. That part, if you're a contractor client, I find a way to do that. If I represent just the public adjuster, I would say don't do it. Never give the money just to the contractor. Always put the homeowner's name on the check as well, just to protect you. That way you can't be dragged into a lawsuit where they say, the check came in, you gave all my money to the contractor, they either did a bad job or, God forbid, ran off with all the money, and this way you're protected. Also, in some states, contractors can't be paid all the money up front. They're only allowed to be paid in thirds or a portion of it. So even if they have a direction to pay in their contractor agreement, you as the public adjuster should always put the homeowner's name on the check. That way the client is making the decision to pay the homeowner, and it's not just you. I've seen public adjusters get involved in those lawsuits, and you don't want to be one of them. Primers. So that's another thing that I made up, and this I think is the most important thing. So if you're a public adjuster, say you're from Oklahoma, and you call me and say, Holly, I'm thinking of getting a license in Texas. I'll pick some heavily regulated states, Florida, or the worst, New Jersey. And I want to work in those 3 states. What do I need to know? So I have these little things I made up called primers, which is basically what you need to know in those states, like a little list of rules for you. Is there a ban on solicitation during certain hours? Is there a proof of loss requirement? What are the rescissionary rights? Is there a fee cap? Is there, what about conflict of interest rules with contractors? What if you're a roofer and a public adjuster? What states are good for that? What states are bad? We'll talk about that more. And what do I need to know in those various states so that I keep you out of trouble? That's my goal. I can help you if you're being investigated or prosecuted, but I'd rather keep you out of trouble in the first place, because you want to be able to just do your job and not get caught up and fined for stupid things like not notifying the state of an address change within 30 days and having things snowball so that they follow you around from state to state. You want to just do it right the first time. The other documents, checklist, the best checklist I've ever seen for the initial meeting or inspection is, there's a lawyer named Tony DiUlio out of Philadelphia. Go on his website. He has the best checklist I've seen, and it's free. You can go right on his website. His firm is Wheeler, DiUlio, and Barnaby. He does a great job with that. So I don't even draft one anymore. I just tell people, just go to Tony DiUlio's website because this is the best. ROI, I can do those like release of information so that you can speak to mortgage companies. They're pretty much standard. Assignments of proceeds, that's more in the contractor arena. I can do an assignment of proceeds. It's different than an assignment of benefits, but that's a speech for another day. Direct pay, that gets more into contractor agreements and appraisal agreements. So if you're a public adjuster and you want to work as an appraiser, the first thing I tell people is get certified, because I won't recommend you to anyone unless you have a certification, because I want to cover myself. I'm not going to recommend someone who has no degree, because if it goes south, then I look bad. So there are some great organizations, Bob Norton, IAUA, I know Bob well. They do a great job. Windstorm certifies people also. And then you need an agreement between you and the client, and it's not your public adjuster contract. There's a guy in Georgia that had one contract and he would check appraiser or public adjuster on there. Can't do that. So we do a separate appraiser agreement that says how you're going to get paid, what your role is, has a few disclaimers on there, and then usually like a compensation schedule that's attached at the end. So you need that agreement. There are lots of agreements. This is the most heavily regulated field. I mean, it's like a lawyer's dream if you do compliance work, but it's tough if you're the public adjuster. I also recommend definitely get a great operating software system. Like Claim Wizard is great if you're a smaller firm just starting out. They're really great. If you grow too much, sometimes you need to move to something else, but definitely use something like that. Don't be one of those people where the state wants to see your documents and you're, sending them to me like literally on the back of toilet paper saying, Holly, can you look this over? Have it so you can just push a button and send it to the state. The other thing is with documents and claims management systems, if you're doing a claim log and you're writing notes in there, just remember they're not, even though they're supposed to be notes to yourself on the status of the claim, they're really not. When you're writing that, pretend that a regulator's reading it, because they may ask you for those notes, and if you have stuff in there that's inappropriate, like even just snarky comments people have been prosecuted for in New Jersey, make sure that what's in there is something that you wouldn't mind being read by a regulator. I mean, you can go back and clean it up, but you're not supposed to do that. You can take out like profanity, but you can't change the substance of what's in there. And not only that, you won't have time. Even if you wanted to go back and take out profanity, Matt Mulholland, I'm speaking to you. Then You won't have time because they're going to ask you for 5 years of claim notes. I have one in Maryland, just asked him for 5 years worth of claim notes. He's not going to be able to go back and look at all that stuff. He's just going to send it. So make sure that you don't mind if a regulator reads it. The next thing is when you're traveling from different states, know there are restrictions on fees. Not always caps, but different things. But we'll start with the caps. Varies tremendously by state. So who knows, okay, so the lowest fee cap in the country is 2.5%, and the highest is 33%. Who knows which states they are? We'll see if anybody knows. Go ahead.
Kentucky, the 2.5?
No, that didn't pass. We got it changed to 15. But very good, so that's good. You're up on things. The lowest is, anybody know? Delaware. 2.5% of the first 25,000, and then 12% after that. Does anyone know the highest? Georgia, 33%. The rest, some are 10, some are 12.5, and it's calculated on all different things. So make sure that you know that so you don't accidentally charge too much. Some states have fee caps only on catastrophic losses, and they all define them differently. So you can usually know by going on that state's website. It's usually on there when they declare a catastrophic disaster. And know that in states like Florida, that doesn't apply to commercial claims. I mean, you're probably not charging more than 10% anyway on a commercial claim, but you never know. A commercial building could have, you know, a $2,000 claim, and you might want to charge more than 10%. So again, it also varies in some states by residential versus commercial. But no, Kentucky, we got it raised to 15% across the board, even on cat claims, I think. I'll have to go back and check. But yeah, they were at 2.5 and we moved them up. Can you get a referral fee from a contractor? Can you give a referral fee? Can you be hired by the contractor? These vary by states as well. Some states you can do that. Virginia used to be a state where they said you couldn't share fees between public adjusters and contractors, couldn't have any financial interest in the claim other than as a public adjuster. And they had a carve out. It said, however, you could have your fee paid by the contractor. They just took that out of the law last year. And they said they were going to draft regulations to explain what you can do going forward, but they haven't yet. So right now it's really murky. So if you're doing that, you can probably still get away with it for a little while because they sent out a letter to us saying, you know, we're going to decide it on a case-by-case basis. So what does that mean? Nobody knows, so you're still acting reasonably if you can make a good argument for your case. Is your fee net of attorney's fees or deductibles like in Florida, or both, or not at all? It varies by state. So just be careful about that. Even if you're charging 5%, if your state says you can't take the fee on the deductible or, you know, it's net of attorney's fees, so if it's litigated and the lawyer charges 40%, do you only get your fee on the remaining? Yeah, that's true in some states, so be careful about that. New money versus funds received prior to contract. We talked about that already. That varies from state to state as well. And then bans on solicitation, that's something that varies from state to state. You know, is it during a loss-producing event or is it during specific hours? Is certain speech not covered? And in some states, you have to put the date and time on your contract. But the good thing is, if you're using one of DocuSign or Adobe Sign, you don't have to worry about that because it will automatically date stamp and time stamp it for you. So you don't have to put that line up there that says time and date because you'll always be able to prove that, the date and time to show that it wasn't during those hours. Oh, it looks like that line should have been indented again. One of the other things I talk about in the primers is, do you need a license to solicit claims? Some states you don't. You don't have to be a public adjuster to solicit claims for a public adjuster. Most states you do. I see people from Florida over there, absolutely in Florida. That's probably the strictest. They go on in their regulation to define soliciting a claim for like 3 paragraphs. So absolutely. Arizona, no, you don't. Other states you don't, so you can hire salespeople there or someone who works for you to go out and talk to the client and sign the claim, and you don't have to be a public adjuster. And then there's the fine line that I always get this question. I work with a contractor, they're at the house, they talk to the person, can they send me the claim? Can they tell the person to call me? Can I get them on a Zoom call and just have them sign the contract right there? Can the contractor hand them my contract? There's a fine line between solicitation and referral, and I think kind of deep down you know what that is, and you have to think about it. The contractor can certainly refer you. You as contractors can say, I know a great public adjuster that you can work with. I've worked with this person before. They do a great job. You can even hand the card, but you can't take out their contract and have the homeowner sign it in states that restrict that, which is 90% of them. The public adjuster has to be there or on the phone to discuss, explain the contract and explain the claims process. It's not an answer that people like sometimes, especially public adjusters whose business model is they get all their business from contractors. But it's something that, there's nothing you can do, and you're going to get prosecuted if you keep doing it. Advertising. So one of my clients is actually a radio advertising company, and I help them with compliance because some states have really specific rules on how you can advertise as a public adjuster. Florida, of course. Florida always comes up. If there's ever a state that's the most regulated, just think Florida. But Georgia has specific rules, and in fact, in Georgia, your ad has to be approved by the commissioner, any advertising, technically. I don't know if anyone does that, but that's technically, Matt, does anyone do that? No, I didn't think so. But that's technically the law. Other states like North Carolina, if you're a non-resident, your advertising has to be approved by the commissioner. In most states, you don't have to worry about it, but California now requires that you put your license number on every communication, every email, every letter, everything. So I don't know if you've started to see it, but certain public adjusters now just put their license number in every state they're licensed on their email, and it may be 37 states. And you list it's just the smart thing to do because then you don't have to worry about which state requires it and which state doesn't. And it can change, and it probably will change this year because we're still in the middle of the legislative season for most states, which probably ends in about another month. Some go all year round. Some states have like 2-month legislative sessions. Usually they go till like May or June. And so more states will probably require it in the next 4 weeks. And then Louisiana, is anyone here from Louisiana or just a license there? Yeah, so when I talk about Florida, you're worse off than Florida. Louisiana, of course, you're not supposed to negotiate. You can't charge a contingent fee. You can't say you represent. You can't say you'll advocate for. So if you're a public adjuster who works in other states and has a non-resident license in Louisiana, and your website says, no recovery, no fee, or we advocate for you, or we represent homeowners, you will be fined by Louisiana. They did 100 of those last year and sent cease and desist orders to people, and you have to change your website. They only fined people $1,000, so it wasn't like a big deal, but they went after a lot of, and then you have to report that violation to the other states, and now it follows you all around. All you have to do is put on your website, not all services available in every state, and that covers it. And you have to be really careful about what you say on your website. Not for, oops, I think we lost all the power. There we go. I didn't step on anything, I promise. But so be careful about that, and just make sure if you do work in Louisiana, and the people here, I mean, the law was almost changed last year. It kind of went south pretty quickly. Oh, we lost it again. But we're near the end. Be careful what you say on your website, too, about promises, because that can violate some state laws. Wrapping it up, we'll make this part quick, because I know we don't have a heck of a lot of time. But if you want to be a contractor and a public adjuster, some states you can't do it at all, regardless of whether it's on the same claim. It goes from very, very strict, like Ohio, to you can't do it on the same claim, to, you can do it with certain restrictions. And I think we're having problems back there. The reason I have the word map is to remind myself in 3 different colors. I normally put up a map. I have a map I've done. I've researched it in every state. And the red are states where you can't do it at all. Yellow means with restriction, and green means no restriction. I had them other colors, but it started looking like a political map, and people were giving me a hard time. They were like, why is California blue? Why is California red? Because it's red for public adjusters. Yeah, so I had to change it to red, green, and yellow. And the reason it's not here, so if you want it, email me. The reason it's not here is that we're still in the middle of the legislative season, and I update it at the end of June, like over the summer every year, not just because I have more time, but because the law changes, and I don't want to give you information that's out of date. So if I gave you the one from 2022, it wouldn't be accurate because the law's already changed or about to change in a few states, and those laws haven't passed. They're just bills right now, and who knows what'll happen at the last minute. Sometimes, even though, it's something minor like that, other things come up, they don't get to it, it doesn't pass. So email me at the end of June, and I'm going to update my map. Again, there are so many variations. Some states, like Illinois, it's the business practice. Most public adjusters are also contractors. It's always been that way. Other states like Florida, California, you can't be a public adjuster and a contractor. Texas, of course, you can't, so it really, really varies. The other issue is, can you share your fees with non-public adjusters? And that's a separate issue. Can you, as a public adjuster, pay someone for referring you a claim? Can you pay contractors? In Arizona, you can, maybe. In other states, you can't. In most states, you can't, but you can in some states. I think you can in Arizona. I usually have this part memorized, but I can't remember the law in every state, so more things to consider. In some states, if you do an estimate, you have to copy the insured, and in Florida, you have to send your proof of loss to the insured. And under their new law that's just passing now, you have 60 days to send the proof of loss to the insured, not the carrier. If you don't, they can rescind the contract, and you'll be fined $5,000, and that's already happened to a client of mine. They sent the proof of loss within like 3 weeks to the carrier, and they never sent it to the insured. So they're getting fined. Escrow accounts. Even if your state doesn't require one, don't hold anyone's money unless it's in an escrow account. It's just the smart thing to do. Louisiana doesn't require it because the way Louisiana is set up, you're not supposed to be holding money. Louisiana's law is set up so that you're only allowed to ask for your name to be on a check up to the amount of your fee. That's what you're supposed to put in your contract. That's what the law says. You will routinely get a check with your name and the client's name for the whole amount of the claim, but there's no requirement that you put it into an escrow account. But do it anyway, just protect yourself. And don't just get a separate bank account. Some clients will say, well, I have 2 bank accounts. I use one as the trust account, and I use the other as the operating. No, it has to be a trust account, because that way if you're sued or you go bankrupt, your creditors can't get somebody else's money. That's why it's an escrow or trust account. It's to protect your clients, because it's not your money. I'll try and wrap it up. SOL, statute of limitations, different in every state. I'm not going to rattle them all off, even if I know them, which I don't. So just make sure you pay attention to that. There are charts for everything these days. Policy interpretation rules vary by state on stuff like matching, overhead and profit. I don't know what the loss was there for. Deadlines to report the loss, we got into that, different in every state. So please, don't just think that you can make your proof of loss your notice letter and wait 3 weeks to send it in every state. You have to pay attention to that. Unfair trade practices. Sometimes there are requirements in the unfair trade practices law that aren't in the public adjuster law. So you have to pay attention to all of that. So now we're finished. Bottom line, don't let this be you, my little prison thing. I know Doug Quinn wants to put the carriers in prison, so don't be in the adjoining cell. Pay attention to all of these compliance issues. And also, I'll just end by giving a little pitch for APPIA. I'm the general counsel for APPIA. As you know, APPIA is an association that does good things, but for whatever reason keeps it a secret. They don't let anybody know all the good work that they do, and it's totally revamped. We have a new board. We're in the process of sort of revamping the organization. We're about to send out, we're having a new website done by Sarah Parker, Kuva Media. She's great. I give her a big plug. She does a great job. Please join, try and get involved, be an advocate in your own state. If your state does not have a public adjuster association, start one. It really helps you a lot. You keep up on what's going on and you have a voice. You introduce yourself to the regulators. Just go in and make an appointment and say, hi, I'm a public adjuster. I represent X association. Open a dialogue. That way, if there is an issue, not just with you, but other public adjusters on compliance, they won't just prosecute first. They'll talk to you, and it will really help. Introduce yourself to your legislator. Go up and say, half of them don't even know what public adjusters are. That's the battle that you're fighting. I was at NAIC once, and the new chief of staff for the Illinois Insurance Commissioner came up to me and said, what's a public adjuster? And these are people who are supposed to be regulating you, and they don't even know what it is that you do. I was talking to Cal earlier about they need to learn about the value of what public adjusters do, but just recognizing that you exist and knowing what you do is half the battle. So if you happen to be, find out who your local legislator is, go meet the person, tell them you're a public adjuster and what you do. And then when something comes up, they'll say, well, I know a public adjuster. He or she, I know what that is, and I think it will help a lot. So anyway, I'm finished. I think someone is coming up after me. Thank you so much for allowing me to speak. I really enjoyed meeting all of you.
Thank you, Holly. Our last speaker today.